And good morning and welcome back to Inside the Law. I'm your host, Philip Holloway. This is a big week. Okay. We've got closing arguments slated for today in the New York case against former President Donald Trump. So I wanted to take a few minutes in this special edition to talk with you about closing arguments, what they mean, what we might can expect, and of course, what may happen later on this week. And at the end, before we go, I'm going to break down an ethics complaint that has been filed against Judge Merchan. And I think that will sort of put all of this in the proper context. So, what is a closing argument in the first place? Well, ordinarily, in a typical case, it's where the parties will get to argue persuasively to the jury to find a verdict in their favor. Okay, so in the opening statements, by contrast, opening statements are supposed to be not argumentative, but are supposed to really lay out a roadmap of what the parties think the evidence will show. And then at the end, they can ask the jury to draw inferences and to make certain conclusions of fact based on what they've seen and what they've heard in the courtroom. This case, though, is unusual in so many different ways that we have talked about here inside the law over and over again. So I won't rehash all of those things, but it's important to remember that so far in this case, the prosecution's theory of the case, if you will, is still very vague, very murky. It's not specific. What I mean by that is the so called other crime that Donald Trump's alleged bookkeeping fraud, if you will, the mistaken or allegedly erroneous entry into the books of the Trump organization. If that was done to further some other crime, that's what the DA is using to bootstrap this to a felony. As of now, we really aren't sure exactly what other crime they're talking about. So it's going to be very, very difficult for the defense, I think, to counter that. What am I talking about exactly? Well, the jury instructions, the judge has said the jury does not have to unanimously agree on what predicate crime, what other crime he committed. So the defense, I guess, is going to have to cover all their bases and just argue any potential crime that the jury might conceive of, or is it the two or three or four that the prosecution has suggested that might apply during this case? We really don't know. This is absolutely unprecedented. But if I were representing the former president, one thing that I know that I would do is I would have to be aware that there are going to be a great deal, maybe like 10 or 12 of the potential jurors or the jurors will hate my client. So if you have jurors that absolutely despise your client, what you have to do is you have to help them understand that they need to leave their bias outside the courtroom. So you would approach it something like this, look, you may hate my client. You may not have voted for him. You may think he's the worst president ever. Maybe you think he's the worst human being in the world. Maybe you think that having an alleged affair with a porn star is reprehensible. But even if you believe those things, you've got to understand that the law has to be applied fairly across the board to all defendants. And so you're going to ask the jury to essentially ignore all of those things and to pay attention to what has not been proven in court. There's really been a lot of fluff. There's been a lot of smoke, but there really has been no fire presented by the prosecution. I personally don't think that they have made out the elements of any crime. I think we've learned a lot about Stormy Daniels. We've learned a lot about how the tabloid industry works. We've certainly learned a lot about Michael Cohen and all of the things that he is so troubled with in terms of his legal problems. But what we haven't heard much of is exactly how former President Trump has committed a crime. So when you're making these arguments, if you're representing Donald Trump, you've got to make those arguments to the jury, but also you need to remember there are two lawyers on there. So speak to those individuals as well. Explain to them that look, you might be lawyers, but look, there's been no crime here that's been defined by the prosecution. So you can't base your decision in the jury room on your personal feelings about the defendant in the case. So, in a nutshell, that's how I would handle it. It's expected to take all of the day today. Tomorrow is when the judge will give his jury instructions or his charge to the jury. We will find out once and for all exactly what he's going to tell the jury as far as what kind of law he thinks applies to the case. Now, I want to get into this ethics complaint that's been filed against him because this, I think, illustrates why Judge Merchan is literally standing on the scales of justice, tipping them in favor of the prosecution. All right, we have Congresswoman Elise Stefanik. She filed this with the New York State Commission on Judicial Conduct. I'm sure you've heard about this if you've been following the case in the news. You may have even read this complaint, but I looked at it and I highlighted some things that I think are important because it really, I think, puts the entire case and the entire trial into the proper context. She's writing to the State Commission on Judicial Conduct, alerting them of what she's calling the conflict of interest involving Judge Merchan, who, of course, is currently presiding over this case. She points out that if convicted, President Trump faces a maximum of 136 years potentially in prison. Now, we don't think that there's any real likelihood that Donald Trump would wind up in jail, but it's not off the table. But even if he's not in jail, is he going to be on probation? And by the way, what happens when a presidential candidate is on probation? Does a probation officer get to control his or her travel schedule? Does he have to report once a week, once a month to a probation officer in New York when he's trying to be on the campaign trail? And what if he wins the election? And what if they've got him on probation? How do you supervise on probation a sitting president if it comes to that? So we obviously have some other things to talk about based on the results of this trial once we know what it is. All right, back to the complaint. She points out that he's the presumptive nominee for president, as we just talked about, and the interests of all Americans are at stake here. So the conflict issue, she points out, pertains to Judge Merchan's daughter. Judge Merchan's daughter is president of Authentic Campaigns, which is a group representing Democrat politicians and certain political action committees, PACs. She points out that Representative Adam Schiff of California, one of his daughter's clients, and he's running for the United States Senate now in California. He literally sent out a fundraising email requesting $10 donations, and he stated, quote, in a somber and unprecedented it is somber and unprecedented for a former president to be indicted, but his alleged offenses are unprecedented. Trump will respond as he always does, playing the victim and blaming others for having the temerity to investigate him in the first place. Next, we have the Senate Majority PAC, which is also a client of Merchan's daughter. It leads efforts to elect Democrats to the U.S. Senate. They fired off a similar fundraising email that just after the indictment, and it stated in part, breaking news, Donald Trump indicted by Manhattan grand jury. This is an important moment for our democracy, but our work isn't over. She goes on to point out that since the indictment, Adam Schiff has raised approximately $20 million, and the Senate Majority PAC has raised approximately $73.6 million. And I guess the way it works is Merchan's daughter gets a cut of that, right? Because these people pay her for her consulting services. So this is the trial judge's daughter directly benefiting financially from the very existence of this indictment. And they've got a vested interest in making sure that Donald Trump's legal problems continue and that they even get worse. She points out that Merchan's daughter has raked in nearly $100 million, the clients of Merchan's daughter anyway, and have used President Trump's indictment, a case over which her father presides, as fundraising fodder. So the real meat of this is found in section 100.3E of the rules of judicial conduct for the state of New York. That particular rule, that ethics rule for judges, dictates that Mershon should not preside over this case. Under that section, a judge is disqualified from a case when the judge knows that a person known by the judge to be within the sixth degree of relationship to him. That's a pretty wide sort of scope there, folks. Certainly, a daughter is well within the sixth degree. That's first degree of relationship. If that person has an interest that could be substantially affected by the proceedings. So do you think that the interest of Judge Mershon's daughter could be substantially affected by the proceeding? Absolutely. By the very virtue of the fact that the case exists in the first place, her interests are affected. She points out that if Trump is acquitted, the verdict would benefit him politically and would be detrimental to the clients of Judge Mershon's daughter. So you get that? If he's acquitted, that would be detrimental to Mershon's daughter. That is the linchpin of this, because he being Judge Mershon now, he's got a personal stake at this because he wants to make sure that his daughter's interests are not adversely affected. So she points out that U.S. District Judge Shira Scheindlin, a retired federal judge in New York City, raised concerns about this refusal to recuse himself back on April 5th in a CNN appearance. Part of the quote here is that the judge points out, so there is a statute in New York which says a judge must disqualify himself. It's not may, it's must disqualify himself if a person known by the judge within the sixth degree of relationship, and a daughter is the first degree, has an interest that could be substantially affected by the outcome of the proceeding. So the question here is this daughter likely to profit, to benefit from the outcome of the trial? And the answer obviously is yes. So the judge here points out, Judge Scheindlin, it's not an actual conflict. It's the appearance to a reasonable person that a judge cannot be fair and impartial in light of that relationship. So I think this ethics complaint is right on point. I think that, as she points out, there's a troubling pattern of judicial misconduct by Judge Mershon. Just last Friday, of course, this is some time ago, it was when this was filed, we learned your office privately cautioned him in July over his illegal political donations to Biden and Democrats in 2020. So Congressman Stefanik says that she has learned that this state ethics office privately cautioned Judge Mershon back in July over political donation to Biden and other Democrats. This private caution has not deterred Judge Mershon in his judicial misconduct, as evidenced by this complaint. He appears driven by Democrat partisanship and financial gain for his daughter. I find it absolutely fascinating that she points out that the state judicial ethics commission warned Judge Mershon last July, and it's not deterred him, not in the least. So when we talk about these kinds of decisions where the judge is telling this jury that they do not need to unanimously agree. Oh, and by the way, even Letitia James believes that verdicts must be unanimous in state felony trials. Here, the judge is saying that the members of the jury do not have to unanimously agree on what the so-called other predicate crime was. So you could have 4 people believing it was crime A, 4 people believing it was crime B, and another 4 believing it was crime C, or some combination of all of that. And remember, none of this was specified in the indictment. None of it. The indictment does not put Donald Trump or his lawyers on notice what this so-called other crime is. And without this so-called elusive other crime, this case would be barred by the statute of limitations, because without some other crime here, it becomes a misdemeanor with a 2-year statute of limitations. So we're talking about conduct that occurred in what, 2016, 2017? So the only way that Bragg gets this to be a felony is by pleading and alleging some other crime. And as of yet, we still don't know what that other crime was. All right. Well, I just wanted to come in here just for a few minutes and share with you guys my thoughts about closing argument. There's going to be more on this week. Tomorrow, we should learn exactly what the jury charges are, because presumably tomorrow is when the jury will be instructed. After that, they go to deliberate. They're not sequestered. They're likely to be watching the news, despite everything that the judge warns them, hopefully, not to do that. They're going to watch the news. So they're not sequestered, but nevertheless, we could have a verdict tomorrow. We could have a verdict on Wednesday or Thursday or Friday, presumably maybe even next week. We just don't know. But here's one thing that I am concerned about before we go. Let me just share this with you. What happens when this jury can't reach a verdict? Let's say they come back and they say, Judge, look, we're stuck. Well, that's to be expected, particularly in a major case involving multiple witnesses. It's common for jurors to have questions. So what they'll do is they'll send notes. They'll ask for clarification. They may ask for testimony to be reread. They may ask for exhibits to be reshown. We just don't know. But at some point, let's say they say, look, Your Honor, we're stuck. We can't reach a verdict. Well, the judge will send them back, and he'll say, you've got to keep working. You've got to keep working. He'll give them something known as a dynamite charge that says, look, there's no reason to think that any other jury in the future might do a better job. And so you guys go back there and go back to work. At some point, you got to ask yourself, how many times do you send a jury back to keep working? And of course, this is all hypothetical right this minute, but I do believe in coming days, we're going to see some of this between the judge and the jury. At some point, does this jury just give up and say, okay, we'll go ahead and vote to convict? Because when they don't have to be unanimous on something as important as one of the essential elements of the crime, which is the so-called other crime, it's going to be very maybe tempting for some of them to just say, all right, well, since we don't have to be unanimous, we can just all agree, well, he must have done some other crimes, so we'll just go ahead and convict him. So that's one of my concerns, is that they're going to be sent back to the jury room over and over and over again to keep working. All right. Well, we're going to have to just watch and see. Stay tuned right here inside the law. We're going to be following this very, very closely. And if there's any news that's worth breaking, I promise I'm going to come back here. I'll do videos, I'll do live streams, or I'll record videos, because we want to make sure that we keep an eye on this case, because here inside the law, what we do is we use existing criminal cases, things that are in the news, to see what we can learn. And we're going to learn a lot this week about how juries work, how deliberations work, and how judges sometimes have their thumbs on the scale in favor of the prosecution. We'll see you next time right back here inside the law.